Alrighty, just with the people news. Not attorney, not giving legal advice. Never look straight forward. Always look around and be able to protect yourself by any means necessary. Alright? Use that Second Amendment. Arm yourself with knowledge. Okay? And this is hearsay, but it's educational purposes only. Right? Do your own research. Okay? Nobody is responsible for you. You are responsible for yourself. Okay? Let's see here. I'm a little off here. This is a particular type of writ, okay? When you run late on an appeal, all right? Now, I'm arm length because I have not studied this, okay? So, hearsay. All right, let's listen and see what's going on.
Take it away, Glenn.
Okay, so like we talked about earlier, we have our live stream up on YouTube, and we have.
Side note, I wanted to kind of do this because it is live, and like I said, some of these be moved.
Of our, I've got the document ready to go. We're going to talk about a petition for a writ of coram nobis today. You have to look in your local, state, and federal laws as far as whether this is applicable. It's an extraordinary writ, coram nobis, and what you're doing is you're bringing up some issues that weren't originally brought up in the original case. Now, you're getting them to review it. Okay, so what happened is a friend of mine in New Jersey, they held a show trial for him and convicted him, and then he didn't appeal within the proper time. And so his appeals were exhausted, and so we needed to reopen the case. And so that's why we brought the coram nobis, because then we can appeal that depending on what happens. But we have to, part of the coram nobis is it's an extraordinary writ, and so you have to bring up issues that weren't originally brought up in the original case. In this case, a lot of these issues were brought up, but not all of them. And so get them to reconsider. Anyways, I understand, and I haven't looked at it myself, but I understand under federal, you can do a coram nobis up to 5 years after a conviction. But the states vary depending on whether you can do it in the state or the federal. And you have to, again, you're bringing up issues that weren't originally brought up in the case. So I'm going to share my screen. So this is the coram nobis. This is, I've kind of sanitized it. So the arguments, so we're going to try and make it as big as possible so people can see it. What happened is we filed this petition for a writ of coram nobis about a year ago, and we didn't hear anything about it. And so the judge finally responded. They can take their time on responding to something like this. So we're going to try and.
I'm not going to do this through the whole process, but I just want to kind of
make it as big as possible so people can see it. What happened is we filed this petition for a writ of coram nobis. So we're going to try and make it as big as possible so people can see it. What happened is we filed this petition.
I know the other one's a little harder to see because I don't know if it's my internet or theirs. So, uh,
For a writ of coram nobis about a year ago, and we didn't hear anything about it. And so the judge finally responded. They can take their time on responding to something like this. And so what they did is they denied it because of failure to set forth grounds as set forth in Rule 3.22-2. Well, the thing is full of all sorts of grounds, but anyway, so we're going to specify the grounds now. And so in New Jersey, you have to do in lieu of prerogative writs. Okay, so as a special proceeding under New Jersey statutes that in lieu of prerogative writs. So the respondent in error requests the court to reconsider the judgment in this matter for the following facts that were not available in the court previously, and we're still working on this. This is actually something that he lined out, and so we're going to have to. He went and put these are the grounds that are actually taken from New Jersey codes. A petition for post-conviction relief is cognizable if based upon any of the following grounds: substantial denial in the conviction proceedings of defendant's rights under the Constitution of the United States or the constitutional laws of the state of New Jersey; lack of jurisdiction of the court to impose the judgment rendered upon the defendant's conviction; imposition of sentence in excess of or otherwise not in accordance with a sentence authorized by law if raised together with other grounds cognizable under paragraph A, B, or D of this rule, otherwise a claim alleging the imposition of a sentence. So you can actually bring up just it's a bad sentence. In excess of or otherwise not in accordance with the sentence authorized by law. And then any ground heretofore available as a basis for collateral attack upon a conviction by habeas corpus or any other common law or statutory remedy. So that really opens it up right there, I'll tell you. Anyways, a claim for ineffective assistance of counsel based on trial counsel's failure to file a direct appeal of the judgment of conviction and sentence upon defendant's timely request. So if that's another reason. So the rest of this stuff, the stuff that's yellow, is the stuff that we're planning on using. And this is the grounds. So I've actually, and we're still working on this, but a lot of this stuff, the grounds we didn't have there before. Okay, we just had the petition. And if you read the petition, I mean, it gives you the grounds, but we're going to have to specify these are the grounds. Anyways, the grounds for this petition are denials of due process of laws required by the supreme law of the land, and the judges in every state shall be bound thereby, anything in the constitutional laws of any state to the contrary notwithstanding. Article 6, Clause 2 of this Constitution for the United States of America as follows. Now, the reason we call it this Constitution for the United States of America is because that's what it says in the preamble. We, the people, do ordain and establish this Constitution for the United States of America. Okay. Denial of an Article 3 court is required by Article 3 of this Constitution for the United States of America. Denial of judicial proceedings according to the course of common law is required by 1 Stat 73 and 36 Stat 1087 Judicial Code, and the Northwest Ordinance, which defines the nature of federal jurisdiction and federal territory, Section 14, Article 2. The inhabitants of said territory shall always be entitled to the writ of habeas corpus and trial by jury and of judicial proceedings according to the course of the common law, which is a contract under Section 14. The following articles shall be considered as articles of compact between the original states and the people and the states in said territory, and shall forever remain unalterable, and reaffirmed under Article 6, Clause 1. All debts contracted and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation, and protected by Article 4, Section 2, Clause 1 of this Constitution for the United States of America, which guarantees the citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states. So denial of trial by jury is required by Article 3, so that's the third one. Denial of trial by jury as required by Article 3, and trial by jury as required by Article 6 in amendment. Now, notice, trial by jury here is capitalized, and here it's not. And I don't know how many of you know this, but there was actually, we're doing some videos on the organic law of the United States, okay? And the organic law of the United States, if you go to the Office of Law Revision Counsel, which is a U.S. Department of Justice website, it will tell you what the organic law of the United States is. And it's the Declaration of Independence, it's the Articles of Confederation, and it's the Northwest Ordinance, and it's the Constitution. It's all four of those documents are the organic law of the United States.
We're going to pause right there. How many times have you heard they don't apply now anymore, right? Well, it's never been canceled. So it does still stand. It's just we have not been taught to use these things, right? But it's still available because it was never repealed. All right? Congress never did it. Nobody's ever done it. So all four of them things is still part of the law in this country. So it can be used and utilized in this country as such, since it is still law.
And so I have a friend of mine, Nelson, who is, we basically have a discussion. And I've got some YouTube videos up about it. We're going to have more. He actually is the guy that puts on the event in New Jersey. He lives in New Jersey. They own a couple beach houses, and so he's pretty smart. He's brought some stuff to my attention that I use, quite frankly. And so they had a style committee, and I sent out an announcement too about the Northeast Private Information Share. Maybe I should just put it on the group here while I'm thinking about it. Yeah, maybe I'll do that.
Yeah, I remember after you just got back from your vacation, Nelson came to the mic with you that one night.
Yeah, so let me find the announcement, and here we go. Yeah, right here. I'll upload. So
I had thought of, hey, because
up to you, but I mean, the only way you can do it is through an appeal. You can't just challenge. They just ignore it. You got to get them to answer it. They'll just ignore it. They'll pretend it's not there. There you go. That's the announcement for the Northeast Private Information Share. Call from 13th of April, 19th and 20th of April, 26th and 27th of April, and the costs and everything. So for anybody that's interested. So let's get back to this. Let's see here. Yeah. So, yeah, you can file appeals. You can file stuff all day long into that case, but nobody's going to answer it. Okay. The prosecutor has to answer it, and he's not motivated to because he can sit there and just ignore it, and they do it all the time. I mean, right now, even when they bring a criminal action against you, what you have to do is file a challenge to jurisdiction and then go in there and bring it up to the judge and have an order for him to sign. Either that or be prepared to get the transcript and use it for appeal. And that's the only way. And if they don't answer it, and they don't answer shit all the time, I've had it happen all the time. And so there's nothing forcing them to answer it. Anyways, so denial of trial by jury is required by Article 3. Let's see if we're making sure we're looking at this. Yep, we are. Good. Denial of trial by jury is required.
Alrighty. So the main part of this was that particular type of writ that you may want to look at, right? Especially when you're new beginning and this time frame didn't match and this, that, here, and there. So kind of look up that type of writ in your state, all right? Because it seems to may come in handy. Of course, we know how the judicial branch is, right? They're full of bar unions that just wants to make money, and the prosecutor wants to create their prison population up so they get a 98% conviction rate so they can become a judge, allegedly. These are We the People News. Bye, y'all.